Delve into the world. You're listening to People Think About It. Delve into the world of relationships, business, and politics with hosts Lamar Clark, Dorshell Clark, and Dominique Hagler on People Think About It, where thought-provoking discussions abound.
Hey. Welcome to People Think About It. We have our special guest in here today. We're going to talk about some family law and some situations. And we're going to let our guest introduce herself.
Well, good afternoon, Lamar and Dorshell. Thank you for having me back. I'm excited to be here. My name is Regina Matthews and Judge Matthews, and I currently serve as a magistrate court judge in Gwinnett County. Primarily, my day-to-day duties include hearing cases in Superior Court of Gwinnett County. And so I'm imagining the reason that I'm here is because a lot of the cases that are here are family law cases. In addition to family law cases, I also regularly hear felony criminal cases, all types of civil disputes. So pretty much any kind of case you think about, I probably have heard one of those cases. So happy to be here. I'm originally from Chicago, in case we have any people that listen who are from my hometown. I always got to shout out Chicago, but I'm happy to be here.
Oh, and that's really great. We're glad to have you. So let me ask you, how long have you been a judge?
So this is a little over 3 years at this point. It's kind of hard to keep track because the time just kind of flows from one moment to the next. But I was appointed in December of 2020, appointed by the Superior Court judges in Gwinnett. So there are 11 that serve that are elected. And so those elected judges and the chief magistrate court judge, they do the appointments for the full-time magistrates. And so that happened for me a little over 3 years ago.
Okay, and that's really great. So let me ask you this, because most people that I hear from or talk to, that most people say most judges were attorneys before they were judges. Is that a true statement?
True statement. And so that's a perfect question, because what I should have said in my introduction is that prior to taking the bench, I practiced as an attorney handling family law and criminal defense. So those were my two primary practice areas. And so I did that for a number of years. I started out of law school as a public defender in DeKalb County. So right out of the bat, I did a lot of felony criminal work, misdemeanor criminal defense. And then I went into private practice doing the same thing and adding in family law. And I also spent time as a staff attorney in Gwinnett County Superior Court and as a law clerk in the Northern District of Georgia. So I've done a little bit of everything, but clearly family law and sort of criminal law have been my areas of, I would say, specialty.
And in that, all that you have done in your career, do you feel like that makes you a more well-rounded judge for when you're dealing with your criminal or your family cases? Do you think that gives you better insight?
I do, and I think it's extremely important for people that we elect specifically as judges that they have the right kind of experience before they get on the bench, because while every judge who runs, or every attorney, I guess, who runs to be a judge is an attorney, it doesn't mean that the particular judgeship that they may be trying to get align with their specific background.
Okay, I understand.
For Superior Court, yes, you want a judge who has had some familiarity with family law cases, who has some familiarity with criminal cases, because that's, at least for Gwinnett County, I will say that's 70% of our caseload in Superior Court is going to be your felony criminal cases and your family law cases. So you need to have that kind of experience, I believe, before you get on the bench. And you can't just be a lawyer, let's say, practicing contracts and then, come into Superior Court having to handle felony criminal trials on day one or family law cases on day one, and you've never really done that. I mean, I just don't think it makes you the best candidate.
Okay, I get that. Right. So another question I have to throw at you before we get into talking about the family and law and things that I had someone ask me one time, is there a difference between an attorney and a lawyer?
So no, it's an interchangeable word. Some people use lawyer, some people use attorney. It's kind of like saying tomato or tomato, potato, potato. They mean the same thing.
Because they was saying to me, one took the bar exam, and one I guess was going through the process of taking the bar. So I don't know. I was just asking.
If you're an attorney or a lawyer, that means you have passed the bar and are eligible to practice law. You have a law license.
Okay.
So I would hope that people, I mean, I guess it's possible that people are out there calling themselves a lawyer or an attorney and they haven't passed the bar, but they shouldn't be.
Right.
If you're a lawyer or an attorney, that means you have passed the bar and you have a license to practice law. Now, you can go to law school and get a law degree, so that just means you have a law degree.
Okay.
But it doesn't mean that you're a lawyer or an attorney.
All right. So let's throw some of these questions out here at you. That one of the questions that we have for you today is that if you're going through a divorce, and when you're going through divorce, have you ever been or dealt with a workload where people were going through a divorce and they get right in front of you and decide, hey, this is not what we want to do? How does that, manifest, or what happens at that process?
So it happens, and I guess what I have seen more often than not in cases I would say that sort of fall apart in court are those cases where people have filed for a divorce saying that their marriage is irretrievably broken, or another way of saying that, irreconcilable differences, right? That's one of the ways in which you can get a divorce. What are the grounds for divorce in Georgia? So if you file a divorce on that ground specifically, and then you come to court, and at some point during the evidence it comes out that, you all had an intimate evening last night or 2 days ago, then that makes your divorce null and void, basically. And I have to declare, or I have to dismiss it, because your marriage isn't irretrievably broken if you're still
being
intimate with each other. So I've had to dismiss cases in open court where people have, where it's come out in testimony that people are still sort of with each other, and then they have to start the process all over.
So at the point that they're going through that, and they live in the same household, and one or the other decides to leave that household because the tension that's there, is that considered abandonment? Like when you go through that divorce process and she may say, well, he left and he's been gone for months, would that be considered as abandonment?
So that's a good question. And I guess abandonment is sort of one of the grounds you can seek a divorce, but it's definitely fact specific. And under those facts, I would say that would not be sufficient to grant a divorce, because what you're looking at with abandonment is prior to the time that the marriage sort of fell apart, one of the, persons involved in the marriage was gone for a long period of time. And usually we're talking about like he just up and left 6 months, a year, I don't know where he is. And that is what caused our divorce, because this person, he or she, just up and left out of nowhere and abandoned the marriage. But it wouldn't count if the marriage is sort of already fallen apart. There's sort of a separation, even if the parties are living in the same house. If they're not really living as husband and wife already, and someone decides, this is just a tenuous situation, I want to leave, that's not abandonment. The abandonment has to be the cause of the marriage, of the divorce.
All right, I think that's our caller calling, and let's see what. Hello, caller, Mike. Yes, can you hear us? All right, well, wait a minute. We got to get you on so we can hear you, because we can't hear you. Hold on. Let's see what we're doing here. Can you hear? Can you still hear us, Mike? Let's see. I don't know. We having some technical difficulties. I'm gonna hang up and I'm gonna call you back.
Don't you love when technology does its own thing? It happens, right?
It does.
So, it's funny because we have, for a while during the COVID pandemic, we had a lot of court, virtually all of our court was via Zoom. We had so many technology issues.
So, speaking on abandonment again, like if the couple was paying bills together, right? And then one person decides they don't want to pay the bills anymore or help out with the bills, would that hurt or hinder that person from gaining leverage on the divorce. So, like, let me use a good example. So we doing our bills together and everything, and then things go crazy, go left, and then the other party's like, since we gonna get a divorce, I'm not helping you pay bills no more. Isn't that a grounds for something? Because I think my attorney was like, that neither one of you guys can do that. You got to continue to pay your bills.
Well, definitely once the divorce is filed, you can't sort of cause any property of the marriage to, I guess, be diminished, to go away. You know, like a lot of times people will say, well, like you said, I'm just going to stop paying the mortgage or stop paying the bills. Once a divorce is filed, the expectation is that the parties continue to conduct themselves the way they have been in sharing those responsibilities once the divorce is filed. If for whatever reason someone has indicated that's not what they intend to do, then you can file a motion in the court, in the proceeding, to let the judge know, you know, this has been our historical sort of practice of how we take care of the responsibilities, and you can get intervention from the court to issue an order to require, you know, that person to contribute.
So that means you
and
can't.
That's a temporary. It's called a temporary order.
That means you can't go shut down bank accounts and things of that nature.
That is correct. Once you file a divorce, you are prohibited from closing bank accounts, disposing of property, trying to sell off stuff so it looks like you don't have any assets. Right. You can't, you know, encumber. Let's say you have a home that you have together. You can't go and get, you know, a loan against that home. You can't do anything that's going to change the assets, right? Whatever those assets are, anything that you purchased during your marriage, once you file that divorce, it kind of has to stay put, so to speak.
So caller Mike. Hello?
Yes, sir. Sir.
You can hear me now?
Yes, I can hear you.
All right, so we have Mike here on the line, and we're going to talk to Mike about a little things of, we have the Judge Regina here that could probably answer a couple of questions, you know, dealing with the child support issues and family court issues. So you can throw one of your questions out there.
Yeah. How's it going, everybody? I was just trying to kind of get some insight. When you called me, Mr. Lamar, I was on the phone with my attorney, ironically. But my current situation is I'm trying to get a modification and a legitimization done for my daughter. My child support case is out of Gwinnett County, but they currently reside. My child and her mother currently reside in Bibb County. And at this current moment, I was trying to dealing with a few attorneys, but my current attorney, I hired her in February of 2021. And now it's, you know, of course, 2024, and no traction or no progress has been made on the case. So I was just trying to see, like, what would you advise that I do at this point? Because my arrears are climbing. I'm still not able to establish that relationship with my daughter that I would like to. So I'm just trying to get some insight as to what I should do. I have a mediation scheduled in Bibb County for the 29th of this month. With my attorney and my child's mother, but I'm just trying to see what should I do in this situation, because the current attorney that I have working on the case, she's kind of been BSing on the case. I hired her 3 years ago. I've been instructed by a few other attorneys to go to the bar because she's been completely negligent in my case. So I'm just trying to see what would be your advice for someone in my situation to get the results that I want to get as soon as possible.
All right. Well, that's a good question, and it's probably, unfortunately, not uncommon, unfortunately, for people to have attorneys that are non-responsive, and I think that's a huge issue. I can't give specific advice about your particular legal case because I'm prohibited from doing that as a sitting judge. But what I can tell you is I think the advice that you've been given regarding reaching out to the Georgia bar is probably a good avenue you may want to explore. You can file a claim with the Georgia bar or complaint indicating, you know, how you feel. I guess your attorney has neglected their duties to you as the client, that complaint will be filed, and the Georgia Bar will determine whether or not any further action needs to be taken. Usually there's an investigation into the allegations. If, based on the claim, they feel like there is something there that should be looked into, and that will basically start a chain of investigations, and ultimately they will make a determination as to whether the lawyer has violated a rule of professional conduct. Because all lawyers, when they are admitted to the bar in Georgia, they have to adhere to certain rules of professional conduct. And if they don't, they could face suspension of their license or, disbarment. I don't know the particular circumstances with you and your attorney and why your case would be, I guess, lingering for 3 years. That seems like a long time, but again, I don't know the specifics. It sounds like it may be a modification of, is it child support and legitimation?
Correct.
Is custody?
Yes, ma'am. A modification of the current order and to legitimize my daughter, because she's never been legitimized.
Okay. Is there a dispute regarding custody as well?
There is no dispute, and that's what's kind of getting under my skin as to why it's taking so long. There's no dispute on her end at all.
Okay. Well, in that case, it does sound unusual then that a case would be lingering that long.
So
that's really unusual.
So one of the questions that was posed to us was, okay, and we're talking about the same child or same mother, same father, how can they have a case like in one county and it moved to another county?
So without getting too technical, typically where a case is filed depends on where the person you're filing against resides. So at some point, I'm assuming whoever the responding party was for the child support, which I'm assuming is our caller, he probably resided in Gwinnett County when the mother filed for child support. So that's why the case was filed in Gwinnett. In this case, it sounds like it's now in Bibb because he is now filing a case against her, where she's named as the defendant. And so venue or what county the case is tried in depends in most cases on where the defendant resides. So if the mother of the child resides in Bibb, that is where that case will have to be handled. There are some exceptions, but generally speaking, that's how it works.
So do you end up in a situation where, because we know sometimes the system get a little twisted, whereas if it's a case is filed on you in a Gwinnett and a case is filed on you in Bibb, and then they come, how do they get to the point of saying, okay, this is the amount you have to pay for child support, and you're going to be paying it through what county? Do they decide what county you pay it through? Usually,
whenever child support is established, you pay. I mean, I guess you don't always have to pay through the state, if that makes any sense. So It really doesn't matter, I guess, as far as county-wide, where you pay it. But if there needs to be a modification to that particular order, again, it's going to depend on now where the parties are living. One of the exceptions is, for example, if there's a child support order that's issued, and let's say one party alleges that the other is in contempt of that order, and they're not paying as they should, then that issue will go back to the judge who originally issued that child support. So it would come back to Gwinnett on a contempt case. But if you're trying to modify the original child support amount, like let's say you want to get it lowered because your circumstances have changed, you're going to have to file a brand new case, and that case is going to be filed wherever the defendant lives. And I say defendant because it's the party who you're filing against.
Right. So the next question I would have, even when it's dealing with child support, it seems to be that even when you're asking for a modification of reduction, like I said, the man has to pay child support. It seems like does it seem, it may not be that way, but why does it seem like it's so hard to get a modification once they have set a certain amount?
I don't know that it's difficult. Maybe there's that perception. I will tell you generally what is required when you're seeking a modification is you have to show that there has been some significant change in your financial circumstances that are out of your control. So maybe the difficulty with some people may be that they come to court and they say, well, I don't make as much as I used to when the child support was established, or maybe I just lost my job. Well, the court is going to inquire. I mean, that's not going to be the end of it. The court's going to ask, well, why did you lose your job? Did something you do cause you to lose your job? Because if that is the case, then, that judge may not likely reduce child support because you are the one that caused your income to be decreased. But if it's something that's out of your control, then that is, something the court would consider for modification. But you have to show that there's been some significant change in your circumstances that's not caused by you.
Right.
Because, the theory is that some people can try to purposely get their child support reduced by going to, to a job that's going to pay less to try to avoid having to pay as much child support. But the court is going to look into all of that. If you left a job that you were making, $80,000 and you went and voluntarily went and found a job that pays you less just to, decrease your child support, then that's not going to work because the court's going to say you shouldn't have done that,
So explain this part of, because a lot of people don't understand that visitation and child support is two different situations. Could you break that down a little bit so people have an understanding of that?
Right, and I think that's probably why your caller indicated that he filed a legitimation case too, because at some point he may have come to the realization, either through his attorney or otherwise, that just because you're paying child support doesn't mean that you have any rights to your child. And every state is different, but in Georgia, you can be obligated to pay child support as long as you're the biological parent to a child. Okay. So, at birth, paternity can be established if you're named on the birth certificate, or of course, if there's a paternity test done to show that you are the biological parent, then that's enough to obligate you for child support. But in Georgia, only the mother of a child that is born out of wedlock has any legal rights to that child. So while she may collect child support on behalf of her child, that father has no other rights to the child if they're not married at the time the child is born. So that's why you would file a legitimation case. That would give you legal rights. So if you wanted to have court or visitation, or if you want to have custody, or be able to just make decisions affecting your child, then the only way you can do that, if you're a father who is not married to the mother of your child, the only way you can do that is by filing that legitimation case. But you can still be obligated to pay child support, even if you don't see that child, even if the mother is preventing you from having visitation. Because remember, you don't have that right unless she gives it to you.
And the only way you can establish visitation is to get legitimization.
That's correct.
And then,
unless the mother agree. I mean, a lot of times people never file legitimation because, they don't have any issues with the mother of their child. They have a good relationship and they work it out without having to get the courts involved. But of course, a lot of times that's not the case.
Oh, okay. So let's say from that scenario that happens, that father of that child and that mother child works out some things, and then something goes south. Something goes south, and the mother says, well, you know what? You're still going to pay child support, and you're not seeing this child anymore. Now, you've been doing this for some years. Yeah. So when you go to the court system, how does that affect that situation?
Well, it happens. So it's interesting that you brought up that point because, some mothers who know that they have the upper hand will unfortunately try to use that as a tool, and putting the child sort of as a pawn. The court does not look at that favorably. That is not the type of decision that, if a mother makes that decision, it's not something that looks well in court. So, for instance, if the parties were to come to court and let's say they're fighting over the father having visitation or the father even getting custody, and then it's brought out in the evidence that the mother, for a period of time the parties were working together, and for some reason that has nothing to do with what's in the best interest of the child, she just out of spite, whatever it is, says, okay, I'm cutting off the relationship entirely, and we're not doing this anymore, then that's not going to look favorably upon her, because the court is always interested in how is all of this affecting this child? And so if the father has been active and participating and you just strip that away from the child, that's devastating. Right. And so a court's going to look at that as the factor in making a decision as to, again, if custody is an issue, who might get custody, because after all, the courts are just concerned about what's really in the child's best interest. And just stripping away a parent like that is not good for any child, unless for some reason that parent is, putting the child at risk or is doing things that is contrary to the well-being of that child. But if it's just somebody having spite, and because the parties can't get along, just saying, okay, I'm just Xing you out of the child's life now because I can, not a good thing.
What happens, like, for instance, like my niece, my brother passed away in 2022. Mm-hmm. And so the baby mom decided to cut all ties with
the grandparents.
Does grandparents have rights? And if so, how can we implement those to get the child to be part of the family again?
That's a great question. And believe it or not, that happens a lot. Where one of the parents of the child passes away and the grandparents or other close family members want to have or continue to have a relationship with that child. So, yes, in Georgia, grandparents can file for third-party custody, but they can also file for grandparent visitation rights. Same thing with other close family members, like an aunt or uncle. They can file for visitation rights. Third-party custody can be sort of anyone that's a family member, but it's much more difficult to get actual custody from a natural parent. Yeah, given over to a grandparent.
Can't get custody.
They can in some cases. It's really difficult if there's still a surviving parent. Georgia law basically establishes the principle that no one should have, priority rights to custody over a parent. And that's the case until you can show that parent is unfit, basically.
So what if you take that scenario and you come to court and that child is 10 years old or so and said, I don't want to go over there anymore. So I guess the judge would take that in consideration.
If the child says they don't want to visit with the grandparents?
The grandparents, they say, I don't want to be over there.
The court will take that into consideration for sure.
They'll ask her why?
Yes, in that case, if a grandparent or another close family member is trying to get visitation rights, the court will need to evaluate everything in order to be able to make a decision. But really, what we're looking at, what the law requires us to look at, is whether or not, not having visitation with that child, again, is that going to cause the child some sort of is that going to be in the child's best interest, right? So, or trauma, I guess that's one way to look at it. But if the child is saying, they don't want to continue the relationship, I think it's a harder case. So long as the child is old enough to be able to express their sort of desires, I think most judges, they don't have to, but most judges probably would want to get an inclination as to what the relationship is from the child's perspective with the grandparents, let's say.
So most likely then social service or something like that will become a part of that situation.
So usually what happens in Georgia, we usually appoint guardian ad litems. So it's, and sometimes people get that confused with like a court-appointed special advocate, but I guess they serve similar purposes, but for a guardian ad litem, what the court will do is appoint an attorney who serves as a neutral, who will report and do an investigation on all of the issues surrounding that custody. And that can be any custody case involving, two parents, if it's third-party custody, like a family member's trying to take custody away from a parent, or even for visitation. Sometimes a court will appoint a guardian ad litem to just investigate everyone's sort of position, and then also just to, speak with the child one-on-one and get the child's input. And then that guardian ad litem will make a report to the court as to what they believe, based on everything that they've investigated, what is best. Sometimes that avoids the child from having to come to court to testify, right, which is preferable. Particularly with young children, we want to avoid having to just bring children in the middle of court drama. So one way to do that would be to get the guardian ad litem appointed. They can speak with the child and get information from the child and report it back to everybody.
Okay. So, I mean,
that was a good insight.
You know, because some grandparents do want to have visitation with their grandchildren, and you know, sometimes the parents sit back and like, no, well, because that dad or that mom is not there no more, and they probably didn't like you, so we're taking that child out of your life. So I know that can be a rough thing.
That could be a rough thing, and it happens again more often than people think. But grandparents do have, you know, the right to file an action with the court asking for visitation. Is
that like, can any family member do that? Like, say, like she got aunts and uncles, and that, whether it was a he or she, they were part of the aunts and uncles. Like, can they go to the court and file for that?
So, for visitation, is limited to grandparents' visitation rights. But as I stated earlier, even though it's more difficult and there's sort of a different standard involved, aunts and uncles can and frequently do get custody of children that are, like, let's say their deceased brother's child or what have you. But again, that's more difficult because you have to show that the remaining parent is somehow unfit, which does happen sometimes. If one parent passes away and then you have a remaining parent who's either been a deadbeat, hasn't been around, they're stuck with these children, and the family is like, this person doesn't need to have this child. Let them come live with us. That's the sort of case where other family members can get involved and ask the court for custody.
And you brought up a good thing here. What you said is unfit. What does the court look at as an unfit parent? Because I know, a long time ago when, I had to go through child support and things like that, and I know they told me just because a mother's on drugs doesn't make her unfit, or just because a mother lives a certain type of lifestyle doesn't make her unfit. So what does the court look as an unfit parent? Like, I don't know. So
no, it's a good question, and the law, it's pretty direct, although there's some room for interpretation, which is why if you go in front of one judge versus another judge, they may have sort of their own interpretation of the law. But unfit parent normally requires you, again, to show that parent either has neglected the child or has done something to physically adversely affect the child, such that that parent just is unable to properly care for the day-to-day necessities of that child. So there are cases, that we have in our courts where one parent has a substance use issue. It doesn't necessarily by itself make them an unfit parent. However, if it's, let's say, a custody case between one parent who's not on drugs or who's not struggling with drug addiction and one parent who is, it is going to be more difficult for the court to find that the parent who's actively struggling with drug addiction is going to be a better, more fit parent at that time to have custody of a child. But obviously we look at a lot of different factors, not just that one thing. But you do have parents who struggle with substance abuse who still maintain custody of their children because either they're actively seeking recovery, they're getting treatment, and there hasn't been anything shown that the court can establish that their drug addiction has negatively impacted their care of the child. Like some people, drink out, they're functioning alcoholics. I'm sure you've heard of that. That's a substance, though legal, can affect someone's ability to function, but not everybody, right? You have some people who drink alcohol every day who can function just fine, who can take their children to school, who can help them with homework, who can fix the meals, who can do all the parental things.
So it's kind of a thin line of what an unfit parent could be. I
mean, yeah, it leaves a lot of room for interpretation by whoever that judge is hearing the case. But again, the judge is always bound by law to look at what's in the best interest of the child. But unfit could mean a lot of different things. But if you're not able to, like I said, care for the day-to-day needs of your child in whatever way that could be, you could be deemed to be unfit.
So, what age does a child have to be to decide what parent they want to go with?
That's a great question because it comes up again very often. So in Georgia, once a child is 14, they can pretty much make a decision as to what parent they want to have custody of them. That is not the end all. That's not like the end of the discussion, but it does give a lot of weight, and the court has to give that a lot of weight in determining custody. So if you have that in a case where, let's say, both parents are equally good parents, either one of them would be proper and fit to have custody of the child. If the child just says, this is my preference, and there are no other issues, again, where the court believes that that preference somehow is going to harm the child or be against his or her best interest, then the court is going to likely say this is a parent, who the child will live with, who will have custody. Not every state does that. There's been some discussion in our legislature about whether we should change that law, giving children the
right to decide.
The right to decide, something like that. Some people think that's too much for a child to be able to have to determine, who's stuck in the middle of a custody case.
Right. Because 1 minute you could like daddy, and the next minute you can like mommy,
right.
and
and
daddy emotion.
And children may not always know what's in their best interest, right? Like if you have children or have had them, that a 14-year-old is not going to always make a decision that's in their best interest. They may want to go with the parent who gives them more freedom.
Exactly.
Or maybe the parent who has a nicer house or who has more money, who can buy them things.
My friends live over close to them.
Right.
Like
so they can make that decision based on any number of things. And so, again, that's why some people, particularly in our legislature, are saying maybe we should change this law. But as it stands, as a judge, I have to follow the law that's currently in place. So if a child makes that election, not that that's the only thing that I'm going to consider, but it's pretty definitive unless there's evidence that parent somehow is not the best environment.
Well, and this question here is going to get a little deep, dealing with children, because now we're dealing with the children that's transgender and want to be thing, and I think the legislature is trying to say, well, we're not going to let them make that transformation until they're 18 years old and can make their own decision. How does the court system look on that?
So you mean how would it come into play? I guess I'm just trying to imagine
you
mean if a child expresses during a case
that they want to become transgender and they want to transform. So let's say a little boy wants to transform into a girl, or a girl wants to transform to a boy. Mm-hmm. At that age, I know it's been in the media that a lot of government officials are saying we're not going to let them make that choice at that age. They're going to have to wait till they're 18. Right.
Well, and that's the status of the law as it stands right now, that, children can't do that unless there's parental consent. So it's not really an issue that comes before me because, the law is what it is at this point. And so children can't make that determination on their own.
So the parents can make that determination for them?
They can give their consent to do it. Uh-huh. But, yeah.
Oh, okay. Because the way I was understanding is that they're just trying to pass a bill that's saying that
you mean to have the surgery
done.
Okay, because there's a lot that you're right.
Yeah.
To have the surgery, you have to be 18. But the parent, and what we have seen though is that parents can come to court, for instance, and change their child's name to reflect what gender they might associate with. So while they may not be able to go through a full surgery, a parent can certainly decide to change, a child's name to reflect what gender that child wants to go by. They can also, if it's approved by their medical treatment providers, they can take certain supplements and things. The law, as I understand it, doesn't prohibit you from doing those kind of things. You just can't undergo the ultimate surgery, I guess, right. If that's what you're asking.
So a parent can come in, or a person can come in and change their birth certificate.
You mean change the name? They can't change the gender marker.
Okay, that's what I'm asking. So if you were born a male, mm-hmm. and you want to do the transformation to a female, like you said, you can come in and change your name on that birth certificate,
Right.
but you cannot change your gender.
You cannot change your gender unless and until you have had a gender, what we call gender affirming surgical procedure, where a medical provider, a physician, will have to sign off on a document saying that this surgery has been done, and this person now doesn't have the organs of
what they were born with.
Right, exactly. And so if you get that certification and then you file, with the court a petition to change your birth certificate to reflect a different gender marker, then you can do that, but you have to have that certification.
So when you change your birth certificate, you got to change your Social Security card and all that kind of.
I don't think so. I mean, if you change your name, you probably, I would think, have to change your Social Security number or card. But if you change your gender on your birth certificate, I don't think you have to change your Social Security.
And that has to be
number.
A certified document from a doctor to say that this gender change has totally happened.
Yes.
Okay,
Yes.
That's interesting. Well, we is our caller still on the line? Mike? He must have left. We want to thank you for coming in and giving us some information that we can use going on down the road. We always welcome you as a guest. We don't always have to talk about, child support or divorce and everything. We also know that you're running for office.
I am running for office. Yes, thank you. The election, since you gave me that opportunity, I'm going to take every chance I get to talk about it. But the election is coming up, actually, in May. So May 21st is going to be the date for the primaries. And I'm not going to just talk about my election because there are a lot of important races that are going to be on that ballot in May. Most of them will go on to the general election in November. But some races, like school board candidates and judicial races, they're going to be decided finally in May. They don't go on to November because they're nonpartisan. So my election date, May 21st. Early voting starts April 29th. I'm running for Superior Court in Gwinnett County. So I do ask for your support. JudgeMatthews.com is my website if you want more information. And I'm on all the socials as well.
Judge Matthews, not the one that's on TV, people.
Not Mathis, Matthews. But I get that a lot.
Right.
People always say, "Oh, Judge Mathis." No. He makes way more money than I do. A lot
Judge
more
Matthews.
famous. JudgeMatthews.com.
So before we go, you're running for Superior Court?
Yes.
So just give us a little bit. What court system are you in now?
So I'm a magistrate court judge, and as I indicated earlier, I was appointed by the Superior Court judges that are currently sitting in Superior Court and the chief magistrate. In Gwinnett County, there are 6 of us full-time magistrate judges that are appointed by the Superior Court judges and the chief magistrate, who serve the function of sitting by designation in Superior Court. So that's why when I talked about handling a lot of those family law cases, land disputes, felony criminal cases, I do that in my capacity as a magistrate court judge, but only because I was designated to be able to handle those cases on behalf of the Superior Court judges. So I basically sit by their designation in their courts, helping them, assisting them with resolving those cases. So once elected, I'll pretty much be doing the same thing that I'm doing now. Right? Well, I have the gavel now.
Okay.
But I'll just officially, I'll become a Superior Court judge and not a magistrate judge that is designated to hear cases in Superior Court. I know that's very confusing.
Okay.
But I said all that to say, I'm handling cases now in Superior Court. I'm running for Superior Court. So hopefully those of you who are listening will understand that I'm already doing the work. I'm already making decisions on the cases that Superior Court judges make rulings on.
And give the audience again your site that they can go to.
www.judgematthews.com, and you can find me at Judge Regina Matthews on Instagram, Judge Regina Matthews on Facebook, Regina Matthews for Superior Court on Facebook, and also on LinkedIn.
And people, we want to say this: it's so important to vote. Please vote. Please vote.
And not just in the presidential races, right? Because everybody gets excited in March. I know that's the first, that's the presidential primary, and everyone I think is going to come out. But then you got to come back in May too.
Right.
And if there's a runoff, come back in June.
Because if you don't vote, you can't complain.
You can't complain if you don't vote. And that's how we get stuff done. Our power is through our vote.
Well, you know, like I said, you're welcome to use our platform anytime you want. We want to thank you for coming in to People Think About It. Y'all can reach out to us at peoplethinkaboutit.com. You can also reach us at peoplethinkaboutit@gmail.com. We will look for you to subscribe to us. We release new episodes every Wednesday at 8 p.m. So you can check out the new episodes, and we are no judgment zone, and we want to sit back and just totally give you guys information that, you know, someday you may use down the road. Who knows? Well, once again, thank you for listening to
You have been listening to People Think About
It.
Be sure to subscribe to the show and share it with your friends so that you never miss an episode. A new episode drops every Wednesday at 8 p.m. Thank you for listening.
Thank you.